Did you know that the moment you walk into an attorney's office, he's already formulating in his mind what his closing argument is going to be in your possible case? Did you know that? You didn't? Come join me as I explain. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. This is true. You'll find that the best trial attorneys, the moment you walk into their office to find out whether or not you have a valid basis for a case, the best attorneys are already formulating in their mind how you will come across as a potential witness at trial. They are formulating in their mind how you will look in front of a jury as a potential witness. They are formulating in their mind, after listening to your story, how they can create a favorable closing argument to the jury. If by some chance, during the course of your discussion with the attorney, he is unable to come up with a good closing argument in his own mind, he may not accept you as a client. If the attorney, thinking in his own mind what type of witness you are going to make at trial, decides then and there that you are going to make a terrible witness, he may not accept your case, no matter how good it is. If the attorney cannot reach a conclusion about whether or not he thinks you have a valid basis for a case, he may say, Mrs. Jones, thank you so much for coming in, but I'm not the one to be able to help you. You'll have to try and find another attorney. So you will find that when you are searching for an attorney to help solve your legal problem, whether it's an accident matter or a wrongful death matter or even a medical malpractice matter, when you find an attorney who you believe is right for you and your case, now when the attorney invites you into their office, the best trial attorneys are ones who turn around in their own mind. They're not going to come right out and tell you that's what they're thinking, but they are. They're thinking, how will this person look in front of a jury? What type of story, what type of sense is this going to make to 6 people in the community? How can I craft an argument to get 6 people in the community, the jury, to understand that you are slightly more likely right than wrong? If the attorney is having difficulty doing that after meeting you for the very first time, how do you think it's going to improve from there? And if there's no way to improve it, now the attorney is going to say, wait a second, this doesn't sound like a case that I'd be interested in taking on. And because of that, I won't be able to help you. My best suggestion, try and find another attorney who is. Why is that? It's because an experienced trial attorney knows that when the jury hears about this case for the very first time, they may have the same exact reaction that your attorney is having now as you are describing the series of events that led you to his office, right? You are now telling the story, the reasons why you believe that your doctor was careless, causing you significant harm and injury. Is what you are saying making sense? Is it logical? Did the wrongdoing cause injury? Is the injury significant or permanent? Is there wrongdoing but no connection to your damages? That's what's going through the attorney's mind to see whether or not you may have a valid basis for a case. Now, something else you should know. Most attorneys are not going to be able to tell during that initial meeting whether or not you actually have a valid basis for a case, especially in a medical malpractice case. It's different in a car accident case. In a car accident case, you can walk in, you suffered a fracture, you had surgery. There's no question what happened here, right? The attorney will get the police report, they'll get your medical records. It's clear cut. But in a medical malpractice case, it's different. The attorney, just from the information that he's getting from you, may not be sufficient to determine whether or not your doctor was careless, whether he violated the basic standards of medical care, whether that carelessness was a cause of your injury. And he may not know the extent of your injury at this point. So all of this information has to be obtained by doing a detailed, thorough investigation. But if the attorney, during your conversation, cannot make sense and cannot create a cogent, logical argument, closing argument, that he knows he can make 2 or 3 years down the road in front of a jury at trial, even if you believe you have a valid basis for a case, and even before the attorney has done a thorough, detailed investigation, he may simply say, I'm sorry, this is not the right case for me. So why do I share this with you? I share this with you because in all likelihood you are searching for the perfect and the best attorney to help you solve your problem. And now, in your search to find the right attorney for you, you came across this video and you're wondering, hey, wait a second, that makes sense. And hopefully this will give you additional information. So by the time you pick up the phone to call another attorney, or by the time you go into an attorney's office, you already know what it is that they're thinking about to evaluate your case. You know, I realize you're watching this because you have questions or concerns about your matter. Well, if you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.